Hello, everyone, and welcome. Thank you very much for joining us today. We hope that everyone is keeping safe and well during this extraordinary time. COVID-19 is obviously having an impact on every aspect of life and business in general. Our webinar series covers a range of topics, including the way in which businesses are impacted and coping with the pandemic. Focus of the seminar today is on M&A in the context of COVID-19. We're not clear yet on how long that context will actually last, but we certainly expect there'll be an impact on M&A activity and deal dynamics even post-pandemic. In presenting today and answering your questions, we'll provide an overview of what we're seeing in M&A, as well as some guidance for those in the middle of doing deals or contemplating transactions. Just by way of introduction, my name is Neil Kravitz. I'm a partner in our M&A group and co-head of our cross-border US practice. Just do a quick introduction of the other panelists today. So presenting first on material adverse change provisions is Gesta Abols, who's a partner in our M&A and capital markets group as well, and co-head of our cross-border US practice. Grant McGlaughlin will be presenting on private equity environment in the context of COVID-19. Grant is co-head of our private equity practice. Speaking on due diligence, representation, and warranty issues is Antonella Penta, who's a partner in our M&A group in the Montreal office. Tony Domenico in our Toronto office, who's co-head of our antitrust competition and marketing group, will speak on merger review globally and domestically in the context of COVID-19. And Andrew House, who's counsel in our Ottawa office in our government relations practice, will speak on national security reviews in the COVID era, and then we'll follow with a Q&A session at the end. So with that, I'll turn it over to Gesta to cover our first topic.
Thanks, Neil, and thank you for joining this webinar. I'm delighted to be here and hope everyone is keeping well given the circumstance. I'm going to be talking about material adverse change provisions in M&A agreements. Next slide, please. So why are we talking about this? Why does it matter? Well, if the pandemic amounts to a material adverse change, which is a defined term in virtually every merger agreement, it has a profound impact on the rights of buyers and sellers. If it is a MAC, it means a buyer can walk away from a deal without penalty or legal exposure. On the other hand, if it's not a MAC and the buyer tries to walk away, the seller can successfully go to court, seek damages and or specific performance, actually forcing a buyer to close on a deal. So the stakes are high. Next slide, please. So what is a MAC? A MAC, the material adverse change, is a defined term in virtually every merger agreement. It takes up almost an entire page and is often the source of heated negotiation. And notwithstanding the time and effort that lawyers and their clients put into defining an appropriate term, there's no case law essentially in Canada on what it means. And so we need to look to other sources to help interpret the clause. And the main source are the Delaware court decisions, of which there are a number of well-articulated and thoughtful reasons that we can look to. Now, that being said, there's only one case in Delaware where they've actually found a MAC, and the bar is incredibly high. And the main reason for that is we don't want to empower buyer's remorse. We don't want to leave small retail shareholders exposed and have a deal sort of fall away. So it's a high bar, and there's really two key elements to it. One, it has to be material, which is obvious from the name. But it also has to be durationally significant. And I'll talk a little bit more about what those two terms might mean in a moment, but those are the two key elements. And it certainly means it has to be a lot more than a short-term drop and really reflect a fundamental change in the business to be acquired. Next slide, please. So let's look a little bit at the structure of the definition. There's really three elements. Is that it's material and adverse. And the slide gives sort of the lead in. There are nuances and subtleties, but that's essentially that it's going to have a material adverse effect on the business, financial condition, or results of operations of the company and subsidiaries taken as a whole. So that's the first sort of bar you need to get across. And what does it mean to be material? Well, in the one case in Delaware where they found a MAC, the EBITDA of that company had declined 86%. The analyst valuations on that company looked at the share price in the future at $5 to $12. When the deal was announced, it was at $32. So you can see it's a high bar. In fact, in one of the earlier decisions where they didn't find a MAC, and the reason they didn't find the MAC was they were concerned more with the second prong about it being durationally significant. The judge wondered whether a 64% drop in quarterly earnings was enough to be a MAC. So this, what is material, is a very high standard. And that's the first part of it, of the definition. Then, and this is probably the part of the definition that's most relevant for the current situation, there are a number of exclusions. So even though it may be material, we're not going to treat it as a MAC for purposes for the agreement. And those really relate to systematic industry risks, and generally risks that are known by both parties at the time of the agreement. And this gets to the crux of the issue at hand. Is the pandemic in a merger agreement specifically excluded? Is pandemics more generally excluded? Or would one say that this is affecting the entire economy or industry, and we therefore exclude it from being a MAC? Then there's the third element where you recapture these exclusions if for some reason they disproportionately affect the company subject to the deal. So the challenge, if you're just trying to ask this simple question, is the COVID-19 pandemic a MAC? It's almost impossible to answer, and I would suggest it probably would not amount to a MAC because of the general structure of the definition and the inclusion of systemic and industry risks. And many agreements, although not all, would typically include a pandemic outbreak. That being said, you really need to look at the facts, and we can all think of certain businesses that are essentially shut down. So it would seem material, and are they disproportionately impacted? And the other challenge, as I mentioned, there's the materiality, and there's also durationally significant. What does that mean? Well, the cases out of the US talk about measuring the time period in years, not months. So we're only a few months into this pandemic. In North America, 2, 3. It's very difficult to say whether or not the outbreak would constitute a MAC. Now, that's not unique to this issue. That's often the case. And one of the purposes, frankly, of the ambiguity built into the definition of a MAC, notwithstanding the time people spend trying to tailor it, is that there's deliberate uncertainty. And the reason for that is because the stakes are so high, that uncertainty forces parties back to the table. So if you're in the middle of a live deal right now, and the pandemic is obviously causing a lot of issues, I think what you'll see is a lot of parties come back to the table and either change the terms of the deal or negotiate a solution or a settlement where perhaps they will terminate the deal, but a fee will be paid. Next slide, please. This really summarizes sort of what we've been talking about, is that it has the potential to be a MAC in terms of significance, and it could be long lasting, but right now we don't know. You'd have to look at the specific wording of the MAC definition, and pandemics or COVID-19 could be excluded. So general statements at this point in time are impossible. So that's the world of MACs and COVID-19. I'm going to turn it over to Grant McGlaughlin now, who's going to update you on the private equity situation. Thank you, Gesta. My name is Grant McGlaughlin. I'm co-head of the Global Private Equity Group for Fasken. We have over 100 professionals and lawyers across the country and in Johannesburg and London that work with private equity clients on deals on a variety of different industries. It's my pleasure to participate in this panel utilizing appropriate social distancing technology so that we're all safe while we watch this. I'm going to be discussing what we are seeing in private equity environment after the first, as Gus said, kind of 1 or 2 months in this pandemic in North America, probably a month, and see if we can give you some insight of what we're seeing in our shop and how private equity players are looking at this. I've canvassed our group across the country and in other offices. I've talked to many private equity firms during this time period, and I've spoken to a number of colleagues in the US to get an idea of what is the current state of the nation in private equity. First, global M&A, just outside even private equity, has seen a downturn in Q1 across the board of about 16%. I think the reasons for that are, with the U.S. going into an election, I think, in a very robust 2018 and 2019, I think there is, and the Dow being very high and valuations being very high before this pandemic, that there was a little bit of a foot off the gas in M&A in general. In the private equity sector in Q1, the U.S. has stayed fairly flat. Hadn't seen a lot of downturn yet by the end of March. Canada has seen about a 26% decrease in deals, from 162 deals down to 119 deals in Q1. So by the end of March, we're already starting to see a slowdown in M&A and in private equity. And I think all commentators and what our office would be seeing is that we're going to see a slowdown, and possibly a fairly dramatic slowdown, in M&A, both general M&A and private equity, in Q2 and Q3. Some of the things that we have seen, though, is deals that were announced kind of pre-pandemic or early in the year. The good news is we've actually been seeing these deals close. In general, we've been seeing banks step up to the plate and provide the financing that they've committed to. We have not seen in our office, there's been a lot of talk about exercising or utilizing a MAC, but we have not seen that to any great degree for the reasons Gesta had outlined. I did speak to one client that closed the transaction at the end of March, multi-billion-dollar deal, private equity spin out of some assets, and the buyer did not hint or even bring up a renegotiation of the price, and stuck to their commitment and closed the transaction. Like, reputationally, our client had said they will remember for a long time the behavior of that buyer, and they will be invited into any future deals that they're part of. So reputations are being solidified during this difficult time period, and I think people will remember people who stood by their word during it. Overall, we've seen activity in M&A and private equity slow down. People, I would say last week or 2 weeks ago, people are actually rushing to close deals and try to get it done if we were on the seller and even on a private equity deals. But in general, I would say, people are just kind of, if they're in the middle of a deal, they're not walking away from a deals. They're just kind of slowing down. And I think the reason for that is people are still waiting to see what happens here. If this is a V rebound, and we come out of this and people see light at the end of the tunnel and there's business to be done by get to June or July, then people press pause and slow it down for a little bit, and then hit the ground running in the middle of the year and third quarter. As Gesta said, MACs, there's a lot of uncertainty in MACs. There's about 1,000 articles online about MACs. Gesta's description obviously is bang on, that there's a lot of uncertainty whether a MAC would apply in this pandemic. I note that there has been a couple MACs exercised. One private equity deal in Australia, the private equity buyer just said, look, it's been a catastrophic destruction of value and revenue for the target,
and they exercised their MAC. No comment on whether that was appropriate or not, but definitely a lot of people are looking at the MACs in this challenging time period. So with the deals, the practical realities is quarantines and social distancing and travel restrictions are making it difficult for PE firms to do transactions. I would say in my discussions with a number of private equity firms, my colleagues, that in general, PE firms are still in triage mode with their portfolio companies. They're managing cash flows, expense reduction, liquidity, balance sheet issues, determining what they can draw down on revolvers and credit facilities, and how to address their employees and any government programs out there. Look, this is taking up a lot of time and space for the private equity, for the GPs out there, and I think we're still in it, but I think we're getting closer to the end of it, and people are getting their arms around it. Also, the reason why deals are challenging, there's just the obvious that private equity firms, it's difficult to do a deal without meeting management in person. It's almost impossible to do a deal without doing physical diligence on the company. If that's already been done and people are comfortable, they may continue on because the industry might not be affected by COVID, or might be insulated to a certain degree, and you might see deals being done in that space. I understand infrastructure. There's still activity in infrastructure space and stuff going forward, but if they're new deals and the PE firms haven't met with management and they haven't done physical due diligence, the practical reality is it's almost impossible to overcome that. There's only so much you can do on a video conference call. In addition, look, we all read probably the same news feeds and same smart commentators online. It still is pretty uncertain what the future is and when economies are going to come out of this. And that is putting, we're still in the early stages, and that's putting a lot of stress on kind of the normal indicators for a PE deal, the multiples and revenue growth and potential business expansion. Because we're still in the early stage, it's difficult to predict what those numbers are going to be. And that makes valuation probably too uncertain for most buyers to jump back in right now. I think I'm an optimist, and I believe that we're starting to see a little bit of light at the end of the tunnel, and that and once people can see that there's maybe a little bit of confidence, and people will start moving forward on transactions and hopefully getting to a point of actually the social distancing and travel restrictions being lifted. If we can go next slide, please. The good news is, I mentioned before, that the banks have been very clear publicly and with our clients that they are still open for business. The Canadian banks are standing by their commitments in general. If they made commitments before the COVID, if they made commitments, signed commitments, they are sticking by them. So that's keeping the liquidity in the system and allowing deals to close. Obviously, they're cautious about closing it, but we haven't seen them walking away, and they've kind of stood up to the test here and are doing their part. Look, if it's a new deal, credit is tight. Banks are not in the business of making bad loans at bad times, but I think from what I hear that they're still open to do good loans in bad times, and will be but there will be a lot more review and analysis on earnings, revenue generation, and a whole bunch of different things, supply chains. There's just the issues that this crisis pandemic has brought on for businesses is at some point almost overwhelming, but every aspect of a business has been, have had issues. So people are a lot more things to look at. The pricing of leverage debt is going up, which making obviously valuations for the companies lower. So at this stage, the credit markets are not closed, but they're definitely restricted. And look, sellers, if they haven't started a process, I'm involved in a auction process right now. The sellers haven't They haven't stopped the process. They're actually still continuing with the process. They want people to do diligence. They want people to get comfortable in the market and get comfortable in the industry. But look, it's definitely slowing down. And I haven't heard of or seen any new auctions start. It would be pretty wild if a new auction started. But look, if it's an industry outside of the ones affected, look, manufacturers that make PPE, industries in alcohol, a number of other SaaS businesses that are killing it during this time period, like Zoom, there still is very strong business for it. And I understand that look, there's private equity guys crawling over the map to try to even look at those businesses because they think their growth is still going to continue post pandemic. So recent activity, look, there is activity. From our firm, I can tell you across the board, we have weekly private equity, weekly global M&A meetings with 100 people plus to talk about activity we're seeing. And there is activity in the firm. Not everyone has taken their ball and stayed in isolation. People are looking around. For instance, I've had 3 reach out calls this morning on potential transactions in M&A, a potential IPO for the fall, and a potential PIPE. So people are working. People are looking. There's interesting and creative things going on in the market, and there's capital needed, and there's businesses that are doing well. So we think there will be activity. It will be slowed down and a little bit paused. Hopefully we get out of this in the next month or two, and maybe not back to normal, but at least we see some light at the end of the tunnel. As you can see in my slides, before this pandemic, everyone had been talking for the last year that there's a ton of dry powder in private equity. There's lots of money to be deployed. There wasn't enough businesses, and valuations were going too high. So that hasn't changed. That capital is still there. Obviously, private equity firms are going to be a lot more cautious about getting into new acquisitions at this time period. We are receiving a lot of calls on potential distress financing, bridge financing, creative financing to help either portfolio companies or other third parties to get through this time period. And I think private equity firms are seeing possibly very good returns that, look, they may not, their traditional take private or take control type of transaction. They're more open to, we're willing to be a cornerstone strategic investor and have a lower percentage ownership, provided we can get in with the right creative security and structure to give us a return based on the risk. So we are receiving lots of calls on that type of transaction and structure. Pipes for public companies, as I said, I received a call this morning. Definitely a lot of discussions around providing, again, a type of bridge financing for public companies in a pipe financing. I have read that there should be an increased interest in take private deals, given the, not collapse, but the significant downward pressure in the markets. But we've seen kickback in the last 3-4 days, well, last week. I'm a little skeptical. We had a large conference call last week with a bunch of the major firms and the regulator in Canada to discuss potential change, to discuss if changes were needed in the regulatory environment to deal with the uncertainty in the market and massive valuation swings in the trading. And kind of across the board, which replicated what we're finding, that some people are talking opportunistic buying, but really we haven't seen it in any kind of large degree. Of course, I mean, look, there's a lot of people with capital, there's a lot of smart people out there, and their jobs are to find value where possibly value is dislocated from what true value is. Everyone should be looking at that, but we haven't seen this horde of private equity money wanting to rush out and buy cheap public company stocks. Look, I think the boards and advisors will have adequate defenses. And in Canada, as you may be aware, our takeover bid rules require a 105-day period for a takeover bid to be open. And we're hopeful within 105 days that we see, a change in the pandemic, and we have a kind of a little bit more of a path to how we get out of and back to normal business. The mining sector, we feel, has still got some strength. I mean, it's obviously been affected, but we have had some reach outs on potential take privates in the mining sector. Definitely, the precious metals is very strong right now, and they feel that maybe the prices are not reflecting what the prices are for the commodities. So overall, I believe, I mean, I'm optimistic that the activity is not going to go to zero now, and people are looking around. There's lots of smart people out there looking, so we're going to continue to see some activity. So if I get a next slide. I thought I'd just briefly touch base on fundraising and fund formation. The fundraising in Q1 in Canada was very similar to 2019. But look, funds at the GP level are still in shock phase, as I said, or triage stage. I don't see any significant fundraising happening in the next Q2 will be probably very low. But look, that's the first stage of what will happen with fundraising, is that it will soften in the next 2 to 4 months. But there's and we've had a number of calls from GPs already thinking of creative structures and funds and possibly wanting to raise new money for these new funds. And that's what they're paid to do, and they're smart, bright people, and they're going to find creative ways to possibly find value in this market and coming out of it. So and in addition, there's a lot of LPs that have money that they've got to deploy. They can't sit on for 6 months and not try to deploy it. So we don't think this is going to be as significant. We think the first stage there's a shock and there's going to be a pause in fundraising for funds, but we're going to see some creative, smart opportunities come, and fundraising, we think at Q3 will start heading back, if not earlier. There's been a lot of discussion on capital calls or LP defaults for GPs. We haven't seen it in Canada we haven't seen it yet. In 2008, we didn't really see it. So we don't think that's going to be a major, but once again, there's a lot of uncertainty, and if this thing gets to be a lot deeper than we expect, then who knows, that could be it. But we hopefully don't expect to see that in the in the fund world at this time. So that's a quick overview of what we're seeing from our firm in the private equity environment. Happy to chat further if anyone has any questions, but I will turn it over to our next speaker, Antonella Penta, who's going to be talking about due diligence and representation and warranty issues in M&A deals. Thank you very much.
Thank you, Grant. Hello, everyone. And I'm just going to reiterate what my colleagues have already said. I hope that everyone is staying safe in this crazy time and staying home and healthy. There's a lot to cover in the time allotted, so I'm going to try to hit the highlights. But of course, if there are any questions, please feel free to email any one of us with your questions. In respect of due diligence in this COVID time, it goes without saying that during the pandemic, and certainly for a period following the end of the pandemic, who knows, maybe even lasting for a while, COVID-19 has and will change the way we conduct diligence. Matters that would have been dealt with only peripherally or maybe with a bird's eye view in the past will likely require more focus in the diligence phase. So for the few deals that are still in progress or that are getting underway during the crisis, virtual diligence will be the only manner to conduct investigations. Buyers are going to need to accept that on-site visits and physical inspections, as well as in-person meetings with management, are obviously not going to be possible. So in some situations, that might make a fulsome diligence difficult. It's just something we're going to have to get used to. From an operational standpoint, we're likely to see buyers put much greater focus on a target's ability to adapt to unforeseen circumstances that are created by the pandemic. Things like business continuity plans will be at the forefront of diligence. They'll be scrutinized to determine whether or not the target's plans include sufficient measures and controls to face unknown and unforeseeable situations like the one we're facing now. Matters such as the company's ability to either scale up or scale down, depending on the industry, in a quick and efficient manner will be carefully analyzed like we haven't seen before. Questions like, can a company put a stop to contracts? Can it source needed materials? What is the employee situation? Can they be laid off or put on some work sharing program, and so on? Supply chain integrity will also be put into question. The manner in which a company can switch suppliers if they have the ability to do so, or if they have the ability to diversify. Obviously, the virus has caused an enormous disruption, we hope temporarily, but obviously supply chain out of China, Europe, and US are disrupted for months to come. So having diversification in supply is going to be of importance and diligence. Next slide, please. In terms of IT diligence, that'll be definitely expanded to focus on security and integrity, as well as on the reliability of disaster recovery plans. We'll be looking at the target's ability to provide network access to employees working remotely, which gives way to a host of questions, including those relating to cybersecurity, whether or not there's an ability to support a maximum number of users, and ensuring just generally that the transfer of information is done so in a secure manner. From a financial standpoint, a potential buyer will want to know what impact the pandemic has had and will have on a target's financial performance and how forecasts are affected. They'll want to look at the target's ability to meet financing conditions, the adequacy of cash reserves, the integrity of accounts receivables, is it able to pay suppliers, and working capital issues, risk of insolvency, all those issues will be looked at carefully. Obviously, most companies have taken a hit on liquidity, so it'll be important to understand what measures have been put in place to protect liquidity, whether through deferrals of non-essential spending or concessions made with customers, borrowers, lessees, anyone basically to help them through the crisis. Next slide. From a contract standpoint, a buyer will want to pay particular attention to the termination rights under material contracts, including those in the event of insolvency and force majeure events. A good understanding will be needed of the steps required to declare force majeure under the contracts and the length of time that the performance for force majeure is excused and what mitigation measures would be required to be taken. In terms of insurance policies, obviously will need to be looked at and determine if there are any carve-outs to coverage. We'll also see a new focus being placed on certain HR and employment matters to the extent that the target has taken measures to reduce its workforce in light of COVID. The buyer will want to ensure that such measures comply with employment laws and that there's no exposure to claims in that respect. If operations are still ongoing, a buyer will need to ensure that appropriate workplace safety measures are in place to protect employees. Also, to the extent that a target has taken advantage of any of the newly implemented tax subsidies, a buyer will want to ensure that complete and accurate records are kept along with supporting documentation in the event that there is a tax audit. We're constantly being reminded by our Prime Minister of the severe consequences that will be imposed on employers who seek and obtain assistance without actually qualifying. So that will be important to make sure good record keeping is in place. So we see that the diligence focus is changing, and it'll be interesting to see whether these changes are here to stay or if they're just temporary. Next slide. In terms of representations and warranties in our agreements, these are obviously a key aspect of any transaction as they set the stage for who bears the risk of certain losses. Inevitably, at least in the short term, we can expect to see COVID-related representations and warranties being sought by buyers. So otherwise, standard reps will be tailored to address COVID issues, and the extent to which a seller will agree to bear the risk of the pandemic will obviously be subject to a lot of negotiation. We may begin to see new reps and warranties dealing specifically with COVID, things like ensuring that laws related to the pandemic have been fully complied with, or that actions taken in response have been taken in a legal and a sound business manner. Much like in the diligence process, representations with respect to the target's emergency protocols, the contingency planning, business continuity processes, and similar matters will need to be expanded to ensure the realities of the pandemic are dealt with. Other standard reps and warranties will also need to be tailored. For instance, we can think of, the customer and supplier representation. Though that rep will need to deal with whether business volume has changed, either because the customer or supplier is affected by laws that restrict their business in whole or in part, or because of supply chain issues that might be faced. Similarly, the absence of certain changes representation. Many businesses are not operating in the ordinary course, so consideration will need to be given as to whether any COVID-related situations should be excluded. For deals in process, in the unlikely absence of a MAC clause, as most agreements today do have a MAC clause, this rep could function as a backdoor MAC if reps need to be brought down at closing. Next slide, please. In terms of the material contracts, rep will want to know the status of the contracts, and we'll need to know, are they still in force? Are there any breaches? Have we received any claims? Have we given any claims? What the termination rights are, either for force majeure or other matters. Those will be closely looked at. The information technology rep, buyers will want to expand that rep to ensure that the target's IT systems are robust enough to allow for remote access and that their cybersecurity systems are adequate to deal with the pandemic. So these are just a few examples of where we foresee changes, but every rep will need to be considered, and a decision as to whether any changes are necessary will need to be taken. In the process, sellers will want to respond to these reps by either seeking knowledge, materiality, or subject to law qualifiers, and also disclosing as much as possible in disclosure schedules about the impact or even the potential impact of COVID to ensure that they're sufficiently protected in the event of a claim and that the buyer is sufficiently aware. For live deals, the seller will need to consider whether the accuracy of reps at closing can be confirmed, and also consider any recourse if a bring down is not already in the agreement. Next slide, please. With respect to rep and warranty insurance, as with everything else today, the rep and warranty insurance market is quickly evolving in response to COVID, and will likely continue to do so as the effects of the pandemic become clearer. I'm going to limit the discussion here to the trends that we're seeing developing in the area. And although the frequency of deals has slowed and ongoing deals are being pushed further and further back, the rep and warranty insurance market is still open, and although with some adjustments to the underwriting and the diligence process. For deals that include rep and warranty insurance, COVID-related issues would not be currently covered. In most cases, our rep and warranty insurance doesn't cover known issues. But even despite this, some insurers have started adding specific exclusions related to COVID-19, including with respect to business interruption losses. In fact, COVID-19 exclusions seem to be the new norm, especially in sectors that are dependent on supply chain. The approach taken to exclusions varies from insurer to insurer, where some insurers are proposing complete exclusions to losses arising from the pandemic. Others seem to be open to dealing with exclusions on a case-by-case basis, depending on the expected effect on the target's business. Like I said earlier, this is still very much evolving, and different insurers may be more open to others to dealing with the exclusions on a case-by-case basis. And some insurers have shown openness in applying the exclusion with respect to certain breaches, but not others. Buyers are going to want to carefully consider which reps will be immune to the effects of COVID and be ready to negotiate to carve those out. Next slide, please. As between buyers and sellers, they'll want to decide how to allocate the risk of any COVID exclusion in the insurance policy, whether it be through a specific indemnity to cover the exclusion or through purchase price adjustments or interim operating covenants. That'll need to be negotiated between buyer and seller. One thing is sure, diligence conducted by underwriters on matters that are affected by COVID will be heightened, just as it is for a buyer's diligence. More scrutiny will be placed on reps and warranties that may be affected by the pandemic, as well as the business of the target in general. Matters, just like in the buyer's diligence, matters like financial and supply chain, business continuity, employment, and others will be looked at from a different angle. What we have been seeing on recent diligence calls is that they tend to be longer and more substantive when it comes to discussing the effect of the pandemic on the business and the ability of the target to bring down the reps and warranties when we have a two-step transaction, especially when those transactions involve a long interim period. On a positive note, for now at least, it seems that the premiums and the retentions have remained stable for the most part. This may change, but for now, and given the decrease in deal activity, there seems to be room to negotiate the cost of premiums and retentions as competition grows in the face of a lower deal market. That concludes my part of the presentation. I will turn it now over to my colleague, Tony Domenico.
Well, good afternoon, everyone, and welcome to our presentation. I hope everyone is keeping well and safe in the circumstances. So again, my name is Tony Domenico. I am the co-leader of Fasken's Antitrust Competition and Marketing Group. And before coming back to Fasken, I was counsel to the Competition Bureau and the Commissioner of Competition. I must say, when I was there, I never experienced anything quite like this, but I did have some experience reviewing mergers, and hope to provide you with some practical guidance as to how to manage this situation. So what I hope to discuss here today is really 5 things. First being where we are, and that has regard to both domestic and global merger review enforcement. And then want to turn my time to short and medium term observations and impacts that we should all keep in mind when we're transaction planning. Then moving on to some practical transaction planning considerations that you should think about. Moving then to strategies and best practices to minimize risks of delay moving forward. And then after that, taking a step back to really looking beyond the immediate crisis and things and trends we should keep in mind when we're thinking about antitrust moving forward. So next slide. So one thing to appreciate is that there has been an absolute plethora of guidance and information coming out of all the antitrust and competition agencies around the world, whether that be looking at the US FTC DOJ, looking at the European Union, or even looking at the ICN, which is a network of agencies around the world. And we've been inundated with a lot of different kinds of pieces of guidance, whether it relates to competitor collaborations, but it also relates to merger review. And what's important to focus on with respect to merger review is that there are issues that are both substantive and procedural that we all hope to keep in mind. And that's what I want to expand upon a bit today. So moving on to the next slide. So this is Matthew Boswell, the Commissioner of Competition, a person I used to report to, and he came out with a statement a couple of weeks ago that really focuses in on process points with respect to mergers. And as you can see from his statement, he's really indicating to us that Bureau staff are working remotely, and it's going to be, just as a practical matter, much more challenging for the Competition Bureau to meet what otherwise would be its service standards. So he's signaling to the world that we can expect delays and that everyone should really be patient with respect to having their mergers move forward. And what he's really trying to signal as well is the more proactive we can be on our end, the more practical they can be on their end with respect to managing our merger planning and transactions. So moving on to the next slide. In terms of what the common messages we're hearing from global antitrust agencies, including in Canada, is that there's going to be a delay in the merger review process. And the reason for that is really what's in the second bullet, which is difficulties reaching third-party contacts, such as customers, suppliers, and competitors. Just take a step back. I would say 90% of all the information that antitrust agencies collect around the world arise from voluntary compliance. And for non-complex transactions from a competition perspective, that's really 100%. So what that means is that the Bureau will contact market participants and ask them for their views with respect to the merger, whether they're a supplier, a customer, or at times a competitor. Now, from what I'm hearing through the grapevine is that when these calls are being made now, you're getting one of two responses. You're getting one response, which is, well, I've got nothing else better to do right now. Why don't I talk to you, Competition Bureau? But we're also hearing the dead silence approach, where there's just no one at work and no one returning emails as well. And so unless the Bureau has an opportunity or any other agencies to contact these people, it really does limit the ability of the Bureau to collect information about a merger and how to assess it competitively. The other complication, of course, is that the staff at the Bureau itself are working remotely, and that gives rise to just complications like this. It's hard to get a hold of people. Everyone's information technology at home, I would say, is there or here. It really depends on the circumstances. And government servers are not, I would say, through experience, as good as they could be. So I know the government is struggling right now in terms of trying to even manage their own IT moving forward. Oftentimes in a complex merger, you're going to have to deal with face-to-face meetings, meeting with parties really to assess credibility or just to hear from them with respect to remedial proposals or submissions being made about why a transaction ought not give rise to a substantial lessening or prevention of competition. And that's just being postponed right now. There is talk on some matters that at least I'm working on right now, are having more formal meetings, at least by phone, and maybe even trying to have more of a video conference, but that is something they're working on and it's just being delayed through the process. And the other complication is adjudicated delays. In Canada, to the extent mergers are being challenged, that happens at a specialized tribunal called the Competition Tribunal. And that tribunal right now is really closed for business, but for sort of pressing matters that can be heard by telephone. Now, the fact that it's closed has more of a tactical and a substantive sort of reality. The substantive reality is there's just hard to get before the court. So if there has to be a challenge of a merger, whether or not at an interlocutory level or finally, it's just physically hard to get there. But tactically, sometimes the Bureau can use that threat to go to the Competition Tribunal as a means by which to get the parties to really talk remedies where necessary. And without that much leverage, given the fact that it's harder to get to the tribunal, not impossible, but harder to get to the tribunal, that leverage point sort of dissipates a bit. So as a result, there's also a tactical dynamic that's changed with respect to what normally occurs with respect to the adjudication of mergers. So next slide. So in terms of sort of practical realities moving forward, I think we can say that there are going to be fewer newer transactions being put before the Bureau. I think that transactions that are going to be under negotiation that are complicated from a competition perspective can be suspended or abandoned entirely, depending upon whether the parties want to go through with it or whether the Bureau has the bandwidth and the resources to invest in it. And with respect to ongoing matters, we can expect a slower pace. But I must say, at the same time, I don't think the Bureau want to be seen as obstructing constructive economic activity. And I think we can anticipate that the Bureau is going to strive to really be practical and expedite the review of mergers that at the end of the day are not going to give rise to either an outright prohibition or a remedy. Personally, I've had experiences where I've had non-complex deals actually clear sooner than normal. In fact, by a few days. That could be a coincidence, or it could be the fact that, and I'm speculating here, but perhaps not every rock's being uncovered in deals that the Bureau knows ought not give rise to a substantial lessening or prevention of competition. So I don't want to suggest that it's doomsday and that all your mergers, whether complex or non-complex, are not going to be reviewed in a timely way. I just think it's going to be sporadic. And in fact, I've had the experience where I've actually had sooner clearance than I expected in these circumstances, without really being sure why, but I was certainly pleased and the client was pleased with that result. So moving on to the next slide. So in terms of the impact on transactions generally, I think the pre-merger notification regime will stay the same. So we've heard from other agencies around the world where there have been talk of potential changes substantively to legal tests. We have not had that in Canada, so I think your regimes should be expected to be the same. Though I do think that we can expect maybe perhaps greater uses of different techniques. There's an exception for debt workouts that is pretty prescribed, but may be more used now than it has been in the past, just having regard to the economic environment we're in. There has, pre-COVID-19, there was a trend towards a higher increase in reviews of non-notifiable transactions. So in Canada, the threshold for notifiability is fairly high. Most transactions don't meet that threshold. Now, the Bureau does have the jurisdiction technically to review any merger transaction, whether notifiable or not, up to 1 year post-closing. And the Bureau did signal about 6 to 8 months ago that they were going to increase its intelligence unit and its review of non-notifiable transactions, because they had a concern that transactions that may not meet an artificial threshold could have a substantial lessening or prevention of competition as a whole. And so we expect that to continue and the focus to really be on COVID-related products or services. So we've seen in the US, there's already been talk of this notion of killer acquisition. This is where a large entity with a lot of market power acquires smaller businesses as a means to, in theory and allegedly, sustain their own market power by preventing new entrants or new competitors from coming into the market. And we're seeing talk of this already in the United States in the context of COVID-related products, whether ventilators or masks or things of that nature. And so transactions that maybe that didn't meet a certain threshold are now being viewed more closely, having regard to these circumstances. So if you are a business that has COVID-related products in your bailiwick, you should really be thinking about those kinds of issues when you're talking about merger review. Some people ask, what is a COVID-19 product? Very good question. It can be a broad array of things. The starting point I look at today is actually the province of Ontario has implemented an emergency price gouging measure with respect to COVID-related products. And so there they actually have a definition of COVID-related products that I've been looking at. It's things that you would probably from a common sense point of view, think about, like ventilators, masks, medical products, and things of the like. But it's a broad definition, and I use that as my starting point now. But you can appreciate there are things well beyond that can be COVID-related that could be captured as a COVID-19 product. So things just to keep in mind when you're thinking about your transactions. Next step, or slide, I should say. So when we're looking at observations now moving towards the sort of small or short-term to medium-term, I think it's important to point out that the legal test for transactions has remained the same. It's whether or not your merger gives rise to a substantial lessening or prevention of competition. That's in theory what the test is. I'm going to comment in a moment that I think that test substantively is going to be under a lot of strain moving forward because of this unprecedented circumstance we're in. But before I get there, businesses, as the Bureau will say and other agencies will say, should not expect a free pass or more lenient approach just because of COVID-19. And the Bureau, will not allow short-term benefits to prevail over the long, and that may in the end harm competition in the future. But that being said, I do think that forward-looking analyses and merger review will be challenging given the unpredictable and fast-moving changes that merger review is under. If you can move on to the next slide, I can elaborate a bit. So when we're looking at market trends and we're looking at what will likely happen in the future, i.e., does the merged entity have the ability to increase prices without there being sufficient competitive discipline? Or will the merged entity be able to impact non-price dimensions of competition by limiting output, restricting innovation, things of that sort? You're often looking at the past to see as a proxy to see what would happen in the future. The problem right now is that the future we're in, or the current circumstance we're in, is fairly unprecedented. It's hard to look at a circumstance in the past where we've quite had this kind of structure. So trying to use those kinds of analytical and economic approaches for, say, defining markets or looking at substantial lessening or prevention of competition frameworks is much more challenging. And I think the Bureau is going to have to sort of face that moving forward when it comes to trying to analyze potential mergers. So I think that's going to be a very significant challenge that I think the enforcers as well as the merging parties have to deal with. So there is a sort of, if we can call it that, a silver lining or opportunity that we can think about when in the context of merger review, and that's the prevalence of the failing or flailing firm arguments as well as the efficiencies defense. So when we're looking at the acquisition of companies, there's oftentimes an argument that can be raised that but for the merger, one of those entities is going to go out of business or is going to be suffering significant hardship as a result of this. And unfortunately, given our current circumstances, that is in fact a defense that we think is going to have to be relied upon more than it has in the past. The only caveat being, again, is that normally the test is, would the company fail but for the merger? That's pretty clear cut, and there is a test to deal with that. Today, from what I'm hearing from clients is, I don't know if I'm going to be failing. I have no idea where we're going in the next month, 2, 3. So Q2 and Q3 may be bad, but I can survive if we make it to Q4. If we're waiting for a vaccine, say, to remedy the situation, and until that happens, we're in lockdown until then, and that's a 12 to 18 month scenario, that's a different predicament, and I won't be in business. And so as a result, there's that nuance that we're hearing a lot, and the agencies, I think, in my respectful view, have to be flexible when it comes to analyzing that defense and not sort of requiring ironclad proof that the entity will be out of business, and may have to rely on some uncertainty given that we're in a pretty unprecedented scenario. With respect to the efficiencies defense, in Canada, we have a defense that allows what's otherwise an anti-competitive merger to be cleared if the efficiency gains arising from the merger exceed that anti-competitive effects. And normally there is these cognizable efficiencies that you can calculate to help form the basis of that. And what we're seeing is that companies that are looking to maximize efficiencies may even try to do that through M&A itself. And when there are instances where there is excess capacity combined with declining demand at the time of the merger, which is something that I think is quite prevalent now, there's actually increased scope for merging parties to make greater use of this efficiencies defense that wasn't otherwise available in the past. So again, another way or opportunity to perhaps try to use the COVID-19 unfortunate circumstances we're under to try to maximize the chances of your transaction being cleared. So if we move on to the next slide. In terms of sort of transactional planning considerations, just to keep in mind, I think first thing to look out is that, there are obviously outside dates that everyone here is very familiar with, but given the increased delays that we're facing in the competition space and perhaps other regulatory spheres as well, we may want to give some thought to longer outside dates being provided for, just having regard to these circumstances. There's always a contractual risk allocation that goes into antitrust review. Sometimes there would be a hell or high water clause or something less than that. You really want to give that some more thought, I would say, given where we are, given the fact that remedies right now are pretty elusive and more difficult to plan for, and maybe having more precision as to who's taking the risk being more important. And force majeure, we've already had a great discussion about that, but we may want to think about force majeure in the context of what parties are obliged to do with respect to securing antitrust or competition clearance. So that's another factor to think about. And with respect to gun jumping issues, there's a lot of talk about gun jumping being more of an issue now. This is where you are jumping the gun and closing your transaction before you're allowed to under the waiting periods under the competition legislation. And often with purchase agreements, there's often a requirement of the sellers to conduct business in the ordinary course consistent with past practice, unless the purchaser consents. What we're hearing is that given with COVID-19, sellers are frequently engaging in conduct that is in fact not consistent with past practice. And so this is raising a lot of questions about whether or not entities are gun jumping or not. So there's a lot of management, or I'd say more so management now on these kinds of issues than we've had in the past. And moving on to the next slide. So when you're thinking about planning from an antitrust perspective, here's some just considerations you may want to give some thought to. Whether changes in circumstance has resulted in your transaction even no longer being notifiable. When we talk about notifiability, we're often looking at the recent audited financial statements of the company. But adjustments to those statements having regard to COVID-19 can impact the book value of assets. And so as a result, it may be the case that your transaction is no longer notifiable when it once was. There's also a requirement that you'll be acquiring an operating business to trigger pre-merger notification. And so in the context where the business may not be operating anymore in light of COVID-19. That's another way perhaps not to avoid notifiability in the context of your transaction. So with respect to timing considerations, if we were to assume that the Bureau is going to take more time with its reviews, there are some strategies you could execute to sort of help your cause to avoid delay. One being is making your competition filing before the agreement is signed. And oftentimes that actually is quite practical, and it's just an issue of who's paying the filing fee in the event the transaction falls apart, because the Bureau, before signing, if it doesn't sign, because the Bureau doesn't issue refunds, unfortunately. Trying to include maybe more detail in your submissions than otherwise. Oftentimes as competition counsel, we can anticipate what kind of questions will be asked, but maybe we don't put it in initially because we have time or don't want to go through the expense of putting that in an initial submission. But since time is of the essence, it may make more sense to include more detail in your submissions than you otherwise would not. I mentioned earlier the issue of getting a hold of people with respect to market contacts. So trying to anticipate that if you have personal contact information of people and people are willing to provide that, giving that to the Bureau so that when they're emailing or trying to call, they can actually get a hold of someone when they otherwise wouldn't. And the other consideration, again, where it's not unduly burdensome, sometimes to get the clock started, you can include both an ARC request, which is sort of like the legal submission that you make to the Bureau, that doesn't start the clock, but it often suffices for the purposes of getting your transaction done and relying on service standards, or putting the Bureau on the clock by actually formally notifying. Because when you notify the Bureau of a transaction formally, it puts the Bureau on a 30-day clock, meaning that if they don't rule on the transaction or challenge it before a 30-day period, subject to extensions, that the parties can go ahead and close the transaction. So putting that pressure on the Bureau can often make sense. Parties oftentimes don't do that because it can be kind of expensive and a bit of a drag to get all this information. But in these circumstances, the time is of the essence. Going ahead and doing that makes a lot of sense. And of course, if you have an international transaction and you're dealing with competition clearance beyond Canada, you really want to ensure coordination is even more structured than it has been, having regard to those considerations. So moving on to the next slide. So I just want to conclude with some bigger picture issues to keep in mind. From a competition perspective, we're always looking at capacity and demand and the relationship between the two. And so with COVID-19 being where it is, and given the fact that it can last a long time, there's going to be lingering excess capacity and depressed demand for potentially a long period of time. And I think that is going to impact the substantive competitive analysis that would be applied oftentimes in transactions, and frankly also lead to different kinds of incentives as to whether or not you wish to proceed with a transaction or not. And I think that if it's a long sustained process of excess capacity and depressed demand, it's bad in many respects, but from a competition perspective can be taken advantage of with respect to perhaps getting transactions cleared that you otherwise wouldn't. I think you're going to have a lot more structures in survival of the fittest. So I think you may be seeing rapid change with lots of different kinds of businesses. And the business model that you may be used to observing when you hear of XY kind of business may be changing. I think we're all seeing businesses around the world changing their business models and changing the way they do business, having regard to COVID-19 and the mandatory necessity to adapt. So as a result of that, I think we need to take a much more critical look and not take for granted that we may understand a business. And I think the regulators need to be taking that closer look as well, having regard to that. And frankly, last point is national champions. Competition law is not a fan of national champions. What we're into is vigorous and effective competition, because the notion is if you have vigorous and effective competition globally, that leads to lower prices and more quality and more selection moving forward. And whether or not you have a national champion is really irrelevant and can be contrary to competition principles. Though if we see more of a retrenchment and less of a focus on globalization and more of a focus on sort of economic structuralism and keeping one state alive through state aid or otherwise, you can potentially see an increase in these kinds of arguments where you please clear this transaction because we were trying to preserve a national champion in this country. And but for that, I won't survive. And so I think that from a high level theoretical point of view could be a direction we go into that I know traditional Chicago school economists would not be in favor of. but you can see more of a threat of that moving forward, having regard to COVID-19 and frankly other factors in globalization that are impacting that. So enough from me for now. I just want to say again, thank you very much for listening. We wish you all the best and hope you're keeping safe. And everything I've just talked about and much more is available on our competition law blog, the Competition Chronicle. And I'd urge you to have a look at it because we're continually adding content that relates to COVID-19 and competition matters moving forward. So subject to any potential further comments or questions on my end, let me ask my partner, Andrew House, to discuss national security developments.
Thank you, Tony, and thanks to all of you for being with us under these strange circumstances. We've had a lot of material today, and what I'm going to be doing is fairly briefly bringing you into an area of M&A that has been relatively rare, but when it happens, it's extremely serious. And if you are involved in this kind of work, it's something that you can't afford not to know about. And certainly, it's the kind of thing that if it happens to you, it's going to be an all hands on deck experience. It's a process called the National Security Review, and it occurs pursuant to Part 4.1 of what's called the Investment Canada Act. And this is an act that has its roots as far back as 1985. And in its more recent iteration, sort of got underway in earnest in or about 2009 with a transaction dealing with McDonald, Detweiler and Associates, which was blocked. And what's interesting about that deal is that it involved a close ally. It involved the United States of America. And we've basically come full circle in some ways back to an era when even our friends are not necessarily our friends for every purpose. And you've seen some of this in the conduct of President Trump in regard to 3M and masks. And I think that in the coming months, you will see more of that. So the trend that we're seeing is one that relates to fewer deals, and you heard Grant talk about that. But when deals are done, far greater scrutiny, particularly in the national security world, and as Tony's just mentioned, in the competition world. I came to Fasken after a period of time in government where I worked on the other side of the table in reviewing deals, specifically as an advisor to the Minister of Public Safety, who in turn advises the Minister of Industry. And just a couple of words about government and the ecosystem of government as it reflects our economy. You have agencies of the federal government who are very opaque in their nature and their operations. These are the security agencies of the federal government, primarily the Canadian Security Intelligence Service and what's called the Communications Security Establishment. And these are agencies that you probably, in many cases, have never interacted with, but you experience what they bring to the table on a regular basis. Their duty is to see to the safety and security of citizens, including corporate citizens, and to make sure that in any acquisition which occurs in regard to a Canadian business, that acquisition does not put Canada's essential security interests at risk. What's interesting in the COVID-19 era is that those essential interests have shifted, or at least how the government perceives those interests have shifted. Let's quickly look at applicability of the Act. It applies to the establishment of a Canadian business. So a foreign entity wants to set up shop in Canada, that would be covered automatically by at least the jurisdiction of the National Security Review. Secondly, and this is what's most common, the acquisition of control of a Canadian business. A foreign entity wants to buy a Canadian business, that will attract and establish the jurisdiction of the Act. And importantly, it's useful to know that there is no minimum threshold. There's no minimum dollar value that would allow a national security review. No transaction is too small, and obviously none is too large. And when it comes to the establishment of a business in Canada, any operations in Canada with an employee in a place of business, no matter how small, that establishes the jurisdiction of the Act. So with those preliminaries out of the way, we'll go to the next slide. And here, what I'd like to do is just look at what has been primarily the areas of focus for the Government of Canada as it evaluates a threat to Canada's national security, and what has now evolved as a result of COVID-19 into the areas which are now as important or more important. So traditionally, the government would worry about things like national security in the context of terrorism. Now, and I'll refer you to the areas of concern on the screen, you've got what's called federally designated areas of critical infrastructure. We've always worried in the M&A context about deals that involved a major bank, the finance sector. We've always been concerned about energy and utilities. Anything that would impact the safety of Canadians more generally has been a catch-all category. But you'll see highlighted or bolded areas that have now become absolutely critical in terms of what the government will look at when it evaluates an acquisition. Health has rocketed to the top of the list. It was always number one on the federal list. Now it truly is number one. And by this, we can think about things like the constituent parts of a ventilator and how to source those parts and whether an acquisition might impact that supply of parts. Personal protective equipment across the medical field, the ability to source masks, even gowns. What might have been a very simple transaction in the past, or at least a transaction that wouldn't attract security scrutiny with a close ally. Let's pick New Zealand, for instance. If a New Zealand company wanted to buy a Canadian outfit that made masks, that would not have been a year ago a transaction that might have attracted a lot of federal scrutiny. First of all, masks were plentiful. Secondly, New Zealand is a close ally, principally as part of what's called the Five Eyes Alliance, which is a wartime intelligence alliance. These are countries with whom we don't have a lot of secrets. We share, so we have a lot of trust. Suddenly, in a time of scarcity on something as simple and as cheap as a mask, there is a lot of competition for supply. We've heard incredible stories about governments taking unprecedented measures to source and obtain things like masks, surgical and N95 masks. So at one point, a deal with a New Zealand company, by way of example, might have been a simple matter of process and due diligence. Now, you may well find yourself in a full-blown national security review as the government evaluates whether supply will be maintained. So we'll go to the next slide. In terms of areas of sensitivity, in the past, as I mentioned, governments were concerned primarily with things like preventing terrorism or preventing cyber espionage. These will in future continue to be major areas of concern. And if a transaction were to, for instance, facilitate the activities of a terrorist group or an organized crime group, let's, for instance, say that a vendor sells a type of encrypted radio system that terrorists might use, it's a no-brainer. You're going to look at a national security review, and I think people were not under any illusion that that might be, they might avoid that. That will continue. What is extremely interesting now is that areas dealing with what's called critical infrastructure, health is one example. You'll see that in the list on the slide. Number 4, interference with critical infrastructure or impairment of critical infrastructure. Something as simple as an acquisition which might affect the food supply in Canada. Food would not have traditionally been associated with a form of critical infrastructure. As you stop and think about it for half a second, of course it is. It's as important as medical supplies. It's as important as the ability to build ventilators in our current time. And so these are deals that would not have attracted scrutiny in the past, and they will attract scrutiny now. A little more exotic, you can see number 6, strategic elements. The elements being referred to there are elements in the periodic table. Here, we've always been concerned, or the government has been concerned, with rare earth elements. Now the government may take a long, hard look at minerals and elements that are more common, but they happen to be used in the creation of something like a ventilator. That type of deal will now face more scrutiny, including with our close allies, because it's a simple matter of scarcity of supply, and it means the government needs to look at that as they evaluate the essential security interests of Canadians or at the local and community level. And here I'd make the point that the Investment Canada Act has always contained a component that made it mandatory for the Minister of Industry to take into account provincial concerns. The provinces didn't have a veto. They still don't have a veto as the Act is currently worded, but their concerns must be taken into account. Suddenly, the provinces are going to play very much more heavily at the table because they are frontline health providers. They have the constitutional duty to provide health care to citizens. And so the federal government is going to be listening a lot more closely to what provincial ministers of health, provincial premiers have to say about a potential deal. That makes the environment for deal making all the more complex, simply because there are more important players at the table. We'll move on to the next slide. This is a depiction of the timeline for a review. One of the issues that folks will be interested in is what's changed. And you heard Tony talk about things with the Competition Bureau largely remaining the same. In certain cases, things got better because people are at home. Maybe their workload is somewhat reduced. They're willing to pick up the phone. Or other people will find it exceptionally difficult to get work done because they're working with family in close proximity. It's critical to remember that the government officials are people. They have the pressures that we all face working from home. That can have real impact on deals. A deal timeline, in the best of times, you can see on screen, can go out to 200 days. It can actually be longer, 230 days, when coupled with what's called a net benefit test. The Investment Review Division of Industry Canada has indicated on its website that it's business as usual. I think that's a laudable goal, and I think we can hope for that. We all know it's not business as usual, and accessing the right people to make sure that a deal is known and that the ability to discuss what's called mitigation is assured. Mitigation is simply the discussion that takes place between deal proponents and the government about how to take a deal that would otherwise be a threat to national security and make it palatable to government agencies, be it personnel changes, supply guarantees, site inspections. And Antonella talked about the difficulty of doing a site inspection as part of due diligence. There are instances when the government wants to come and look at the work site of a target company. That won't be possible right now, and it could really impact or impair a deal, which would otherwise maybe proceed because the proponents would be able to give government the sense of assurance and confidence that risks could be mitigated. So we're dealing with a very complex environment. A lot of the factors are human in nature, and an awareness of those things are critical. With that, I'm going to throw it back to Neil, and if there are questions, we'll certainly field those as well.
Thank you very much, Andrew. Thank you to everybody who participated today. We tried to give you an overview of what we're seeing in terms of the impact of COVID-19 on M&A. I know we threw a lot of information at you. We are seeing a lot of different trends, which we tried to provide an overview. Some are more obvious than others, and Andrew gave a stark example with something that might never have thought to be subject to a national security concern, perhaps being subject to it. We really thank you for your attention. We got a significant number of questions, which shows your interest in this topic. And as moderator of today's session, I'm going to throw a few of those questions at our participants today. If we don't answer your questions or you have other things and you want to reach out to anybody on the panel today, please feel free to do so. You'll have all of our contact information on the materials for the webinar. So a bunch of the questions require us to look into a proverbial crystal ball. And our crystal ball is not perfectly clear, but we'll do our best. First question is for Grant. So Grant, on the private equity side, you mentioned this, there's a lot of so-called dry powder, a lot of capital that's been built up, and there are a number of factors that will impact this, including the availability of debt in the market, et cetera. How do you see PE activity and deal flow and dynamics following the pandemic? And following the pandemic is sort of a strange term because we don't know what that will be, but is it a slow trickle back with some caution, or is it an open the floodgates and people are gonna sort of rush past the starting line to see where they can get before the other players?
Yeah, thanks for the question, Neil. Look, this is on everyone's mind of how this will unfold. And as you said, everyone's crystal ball is currently a little bit foggy right now, but I'll look into my crystal ball and see and give you an idea what I think will happen. So I think there'll be a two-stage kind of rollout of what happens here. I think we're still in the shock phase, a little bit of a triage stage, and I think that will probably last anywhere from another 2 to 6 weeks, where it's really way too much uncertainty for people to do much, to do valuations, to travel, to see people. So we're still in that phase, but after that phase, I think we will see a moderate people start getting back into the market, looking a little bit more activity, poking and prodding, and that I think could last 4 to 8 weeks. But I do think come the fall, provided this is not a longer term, provided this is a relatively short term occurrence and we can get back to normal by September 1, I think we're going to see pretty decent deal flow in the fall. If we look back to 2008, with that financial crisis, we actually saw a post 2008 actually very active M&A environment, both for public M&A and for private equity. And I think if we have a 2 to 4 month pause here, where the uncertainty causes people not to be able to do deals, I think you're going to see pent up demand to do deals. Look, there's a lot of capital out there that needs to be deployed. There's a lot of pension funds and other people that have savings and pensions that need to be put in and allocated to their relevant investment buckets, and private equity is one of them. So I am optimistic come September 1, we will see we'll probably see a pretty active market. Will it be the same as we saw in 2018 and 2019 at that time period? Not sure, but I think it'll be climbing up. And then I think in 2021, provided again that we see an end to this pandemic, I think activity levels should get back to where we were pre-pandemic.
All right, great. Thanks very much, Grant. Next slide, please. So the next question is another forward-looking question. This one's for Gesta. There were a number of cases, you referred to them in Delaware in particular, following the financial crisis in 2008, where some parties tried to assert that there was a MAC, most of them unsuccessful. Of course, we're very reluctant for the reasons that you set out. This situation seems to be a little bit different in that it's a financial crisis that's been caused by an underlying event, a global pandemic. Do you think there's going to be more cases, and do you think they might be treated a little bit differently than the cases that were coming out of 2008?
Thanks, Neil, and thanks for the question. I don't think the legal principles have changed, but what the broad nature of this pandemic and the devastating impact that it's having on businesses may not amount to a MAC because of the structure of the definition and how risk is allocated between company-specific risk and broader industry risks. But the courts want to do what's right. Courts want to do what's fair and reasonable. And so, to answer I do think there will be cases. I think people will want to get out of deals. And whether the MAC's the right tool, or some of the failure to bring down reps that Antonella mentioned, or something we haven't really talked about, sort of just general frustration of contract, where we're into a world where things are just so different that the contract doesn't really provide for what people had thought. So I think there will be cases. I don't think the law on MACs is going to particularly change, but the outcome, I think courts will look at the situation, and there will be situations where they'll say, you know what, this isn't what people bargained for, and whether they call it a MAC or some other condition, that they're going to allow for a graceful exit. That would be my sense, because the materiality and the scale of what we're seeing is unprecedented, at least in most of our lifetime.
Thank you. Next slide, please. Okay, thank you. The next question is for Antonella. It deals with representation and warranty insurance, which is obviously a very popular way of dealing with risk allocations between parties. In my experience, certainly the product's evolved over time, and things that used to be exclusions aren't necessarily exclusions anymore. With parties having trouble dealing with allocation of risk of COVID-19 items, do you think the insurance product might develop to cover some of the COVID-19 items to help bridge that gap and meet demand over time?
Thank you, Neil. It's an interesting question. Like I mentioned, this is very much in a state of flux. And the trend we're seeing now is closer to full-out exclusion, with certain insurers willing to exclude on a more case-by-case basis. I think that the decrease in deal activity, as that continues and competition between insurers is heightened, we may start seeing more insurers moving to more targeted exclusions related to specific reps and warranties. I know that brokers are pushing to get insurers there. So I'm not sure that we'll see inclusions per se of COVID coverage, but a shift away from full exclusion is what we're more likely to see, and more focus on targeted exclusions with specific reps. And I do think that parties are going to want to negotiate for more targeted exclusions, as insurers may be willing to negotiate this as the competition is heightened in the face of decreased deal activity.
Thank you. Next slide, please. The last question we have for today is for Andrew and Tony. You touched on this a bit in both of your presentations, but what do you think the outlook of the Competition Bureau and Industry Canada will be on proposed transactions in Canada following COVID-19? Do you think it'll be business as usual? Might there be some administrative approaches that could help deal flow? The other panelists talked about deals start happening again. Do you think that they'll be in line with that to let deals, not let them go through, but to help deals along in the current context? Because we might see floodgates open a little bit when things get back to normal.
So I can speak from the Industry Canada perspective. I think because there's been and there will continue to be such a fundamental shift in the kinds of deals that receive scrutiny, because we're seeing a move towards evaluating critical infrastructure rather than those more traditional security values. A whole new host of people will have contact with the Investment Review Division. And those are people who will not be used to facing the kinds of questions that IRD, because of its good work, puts to people. And there may be a need, I want to say hand-holding, and I mean that in a positive sense, some guidance as to what the security world entails, the nexus between national security and critical infrastructure, which has existed for years inside government, but is not familiar to deal makers. And I think just an increased openness to discussion. There's been I think a marked difficulty in having free and open discussion with security agencies in recent years. That is in part understandable. I think in the current era, or the one we are entering post-COVID-19, is going to be one where people are going to need legitimate answers to legitimate questions from government. And that's something that's going to mean that those of us who work in this area are going to have to facilitate and make sure that people understand where government is coming from, but communicate the needs of clients to government in non-conventional areas, and to make sure that folks are actually speaking to each other in terms that they can mutually understand.
Thanks. Tony, I know you touched on this in your presentation as well. Any additional thoughts there?
Sure. The first thing I would say is that the Competition Bureau and the officers and the commissioner who make up the Bureau will not want to be seen and will not want to get in the way of deal flow. I've worked with the vast majority of people there, and they're very hardworking public servants, and they will not want their conduct or lack of review to be in the way. So they will work as hard as they reasonably can to review transactions in a proactive way. And I think that's very positive. And so in terms of strategies that parties can execute, we touched on them a lot during our presentations, but what I would say is early engagement and proactivity is just recognizing there may be structural barriers or just inevitable issues that cause delays, trying to recognizing what the Bureau needs in order to clear a transaction and really trying to help them get that information so they can satisfy themselves that a transaction ought not to give rise to a concern or not.
Thanks very much. As I indicated, we did receive a good number of questions. Please do feel free to reach out to any of the panelists today. There's also a lot of information that's constantly being updated on our COVID-19 Knowledge Center on our website. But most importantly, we want to thank you very much for your attendance today and for your interest in the topic. And most importantly, please keep well and safe. Thanks again.